combination of feature A and B, that is A plus B, and later on you realize you only need A for some reason. You can do without B. Then we have EPO case law that says if your priority is to A plus B, it doesn't cover A, because A plus B is an invention, but A encompasses other things like A plus C, A plus D, and so on and so forth, and of course only A. And hence, if you have a claim to A in this type of language, and you have a priority to A plus B, a disclosure of A plus B in the priority interval anticipates A. It's prior art, and you have a lack of novelty, the standard rule that I think applies all around the world. A narrow disclosure anticipates a more general disclosure. So far so good. That's standard case law for at least 20 years in Europe and probably in all other parts of the world. And now what was this contention? We have as well case law in Europe saying that procedurally, and I would like to put emphasis on this, a divisional application is to be treated as any other European patent application. And then two British patent attorneys made a proposition, say, well, wait, you have a problem if it's a patent application, and we know that any patent application can be prior art under Article 54.3, which I explain in a second, then of course the divisional can be prior art under this section of the EPC. 54.3 means it's a special provision in the European Patent Convention, which is also mirrored in the national laws, saying that you have a prior European application that has a priority date prior to the priority date of the application under examination, but was published after the priority date. It is prior art for the purposes of novelty. So the contention is if you file a divisional, it can be prior art under Article 54.3, and now if happens what usually happens, you just copy the entire specification, of course comprising the special case from your priority application, and in your parent application you claim the general thing, then so is the contention, the divisional will kill the parent. Or actually the parent may vice versa kill the divisional if the divisional has a more general claim. So it's not a very nice family, parents killing children and vice versa. Actually, this proposition was not taken very seriously, but now we have one Board of Appeal decision that actually followed this. They didn't say why, actually. They just said it's prior art, period. And merely treated this as a matter of fact, which I believe is not. Divisional applications are in a way special. They have a special purpose and so on. They can at least ask a question, and I would like to see this answered in a legally sound way. Is a divisional indeed as prior art as any other application? Just as motivation, if I can claim everything and get valid patent, if I keep everything together in one application and I procedurally split this up in two and suddenly they kill each other, that's not very sound law in my book. Ultimately, this will be an issue to be decided by a large Board of Appeal, but so far this does not seem to have been picked up. What remains is the other thing. If you indeed have a priority for A plus B, and that's important, does a disclosure of A plus B indeed anticipate a general claim which I can more or less split up in A plus B and the rest of it, which I termed A without A plus B or A minus A plus B? And that's an interesting question that goes beyond this proposition by these British patent attorneys, and in fact bears on the general case that your application is more general than the priority document and your prior application. Now, first question, is it possible to have two priorities in one claim? Some people say a claim can only have one priority, and basically it's the newest, or whatever. And indeed, the EPC says, yes, you can have multiple priorities, and at some point in time there was a decision by the enlarged Board of Appeal of the European Patent Office. For those who don't know the structure of the European Patent Office, the enlarged Board of Appeal is a special instance composed of Board of Appeal members that treat questions of law that have been answered differently by different boards of appeal, so to harmonize the case law. And this decision said yes, and they gave some explanations, and they quoted a passage saying, well, if you have a generic term, even then, I should say, it is acceptable to have multiple priorities if you have a number of distinct alternative subject matter. And this was treated in a series of decisions by the boards of appeal in the way to have to saying it's only allowable if you really specify the alternatives in your claim that you have. And now, those of you who are familiar a little bit with European patent practice and our rules on original disclosure, you immediately see that we have a problem there, because if we only have a disclosure of the general thing, and we have a disclosure of the special subject matter, but we do not have a systematic splitting up of the general idea into various categories, what it could be, then we have a problem with original disclosure, because immediately the examiner and the Board of Appeal will jump up. Well, the Board of Appeal will stay sitting and say calmly, this is not allowed, because these alternatives you set out in the claim were not disclosed, you cannot claim it, and so the whole thing goes down. That's the mainstream case law, but now there has been another decision, and in fact, as I learned today, it was followed by a second decision that says, no, that's not correct. You don't have to enumerate everything in the claim. It's simply possible, it's allowable if you conceptually split up the claim in two parts. Basically, the part of the priority document and the part that was not disclosed in the priority document. Very nice. And of course, this would solve the problem, because then for that part that was already disclosed in priority document, A plus B, you have the priority, and A minus A plus B was not disclosed in the priority document, and so it cannot be anticipated. And Mark, I will come to that in a minute again, in another different context, this is only about novelty. Currently, we don't have a consistent case law on this, but this issue about split priorities is going to be referred to the enlarged Board of Appeal. The decision referring this to the enlarged Board of Appeal has not yet been handed down, but it was announced that this will happen. So what can you do in your pending applications? Basically, don't file divisionals with conflicting priorities, or take care that there is no conflicting subject matter in the divisional, so cancel everything out that relates to the special case, but which will probably mean that you have excised the same thing from your application family altogether. You could also waive the priority for the conflicting divisional, but that's not an option if what happens frequently, it has been disclosed in the priority interval. And you may think of entering a disclaimer for earlier subject matter There is again an issue about original disclosure, very complex case law that I cannot enter into it, and we hope that the enlarged Board of Appeal will shed some light on this. Now, this may have been something exotic to you, but now I get to something that was mild poison, and now I get to something deadly poisonous, that's poisonous provisionals, because what is very common practice, you file a provisional in the US, whether you're a US company or not, but it's very fashionable. You file a provisional, later on you claim the priority of this provisional, and of course you broaden the subject matter of your provisional in your subsequent application. And of course all these issues that I just explained about priority, they will strike. And even more, and that's why it's even more deadly poisonous. So far we only talked about novelty, and if the provisional, but what if the subject matter of the provisional was published, which frequently happens because you have some paper that's published at a conference and file a provisional, so this is really not only relevant for prior art but also for inventive step. And that's really dangerous, and in this case even a split priority may not help you. Sometimes it may or it may not, but even if the disclosure, the publication of your provisional doesn't anticipate a completely, there's still the question whether the more general term was obvious in view of your provisional, and that is of course challenging. By the way, a disclaimer would probably not work because it's established case law that you can file a disclaimer to establish an inventive step. So